Ladies and gentlemen, welcome back to another episode of Couple of Nukes. As always, I'm your host, Mr. Whiskey. And on the show, we've had a couple episodes on grieving, on suicide, on just death in general, whether it's children or parents. And we've talked about the community and kind of that process, resources to help you through that. But unfortunately, there are also some headaches that come with that on the financial and legal side, especially if you're not prepared. While none of us want to focus on the death of ourselves or our loved ones as far as wills go and estate planning, the worst part of having someone pass away is if none of that is set up. The next thing you know, you're in court fighting with your siblings or other people who show up out of nowhere, or you're just dealing with financial headaches and paperwork. So it's important, no matter where you are in life, to be planning ahead to have a smooth and easy future. So today we are here with Oscar Vasquez to talk about that, how we can do it efficiently. And, Mr. Vasquez, I'd love for you to break down for us after you introduce yourself also. Just most people know what a will is, but your website mentions a living trust, probate, all these different legal terms. So just a basic breakdown of all the different things involved with when someone passes away, because it's a lot more than just saying who gets what.
Yeah, it is. It's a pretty well, first of all, thank you for having me. And I'm really excited to bring as much value and education to the community, and also thank you for helping us in our crusade to bring awareness to um, estate planning and more importantly, it's we started the crusade. I'll give you a little bit of background. A little bit of background on me is I've been in the real estate industry for over 28 years. And I got into the estate planning because we saw many people go into probate, and it's 68% of people do not have an estate plan, and I don't think it's because they don't care. I think it's more because they don't know, right? Or they
Right.
don't know the resources or the mechanisms that are out there. And I mean, who doesn't want to protect their children and their assets? I mean, those are probably the two nearest things to your heart: your assets or your money and your children, right? Everything else could possibly be secondary. Um, so, give you a little bit of a background. Let's start off with a definition of an estate plan. An estate plan is a series of documents that are needed to be able to have a plan in place to what happens to your things when you pass. That's it, right? And a living trust is a legal contract between you, the parents, and or the grantor is the legal name, and the beneficiary, which are your kids. And the courts help enforce that because it's a legal contract. And that's one of the main reasons why an attorney is not absolutely necessary to create a living trust, not a will, a living trust. As long as you have the legal provisions in every contract or every agreement that the courts recognize. So, with that said, we created what's called estate.prep.com, which is a software that specializes in creating a estate plan. Now, we created that for two reasons. One is to cut costs so you can get the full legal documentation at a fraction of a cost of what a state lawyer or a state approved. Now we can do this throughout the whole country. Every state we have now legal provisions for almost every state, and I think Alaska and Hawaii are the two that we don't have those yet, but we haven't had anybody from there, but we're getting there. So, knowing that a living trust, there's two main reasons why you should have a living trust, and the first reason is that a living trust prevents you from going to probate. Now, probate is court, and the one that reason is because you go to court because the courts say we want to protect the citizens of the land by making sure that their assets or their land goes to the appropriate beneficiaries or the people benefit appropriately. Somebody can't come out of the woodwork. That's what probate really is. It's to protect us. However, now they put minimum thresholds in the provision that says if you own, for example, California, if you own a home or if your minimum value is above 184,500 in it's above $184,000 in California, you have to go to probate. The court gets involved to decide on what happens to your things.
Mm.
However, every state has a minimum. So I like to always tell people, you want to know what the minimum is? Google it. Google Google the what is the minimum amount to avoid probate, or what's the maximum amount I could have in my state or whatever state you live in, Texas, Florida, Colorado. I'll give you an example. In California, it's 184, 184K, 184,000. In Colorado, it's only $60,000, right? So that means going to probate. I'll go deep into what probate really and how it works and how it functions. But if you go in, what if you go into court, the judge finally decides. Now, leads me before I go into probate, I want to talk about the difference between a will and a living trust.
Right.
And
Yeah.
the way I could describe a will and a living trust is a simple fact of being able to a will is a two-page document versus a living trust. It's on average about 170 pages of instruction and laws
Wow.
to be prevented to go in. So that's in as far as tangible. And then the instrument, a will, is basically I love you, I leave you everything, and there's no special provisions. Okay. A living trust gives you instructions. You leave instructions for one of your loved ones or your what's called an executor to execute the provisions in your trust. So I want Johnny to go to school. I'll give you an example of one of there was two provisions that is always on my mind that they were huge aha moments, and one of them was on the trust they put a provision for a young adult that had history with drug addiction, and the provision was that they got their distribution on a monthly basis. However, they had to take and report to the executor a clean bill of health for being drug free. They had to take a drug test every
Wow.
month to be able to get that distribution. And when I asked the educator, really, what, why? And she said, well, he's either going to stay clean when either he's going to remain clean when I'm alive, or he's going to remain clean when I'm dead. Either way, in order for him to benefit from his estate, he's going to stay clean or he doesn't receive payments. That was like, wow, that's a very,
Yeah.
very thoughtful, and saying, wow, that's how much love and care and thought you put into your living trust, into your estate plan. And the second one that I've seen the provision was in a what's called a special needs trust because it becomes a subtrust. So if you have a child that is in special needs, either disabled or mentally or down, the child had Down syndrome, and one of their biggest highlights of their life of their year is they have a countdown calendar at home, and they go to an amusement park every year because that's the highlight of the child's
Mm.
life. And so that it was an educator. We work a lot with teachers and educators for their estate planning and financial services. And they said, really, that's interesting. She goes, yeah. She goes, we have a countdown. So she put aside a $10,000 annuity now, so it can compound over time. So every year she got 4 tickets to go to from that portion, got
Right,
four
right.
tickets to take her and 4 people, 3 other people to take her to an amusement park every year. And I go, wow, that's when I first saw it, I was like, wow, you know, that's crazy. And then, my when I told my wife, she made a very interesting comment. She said, "No, that's how much love and detailed and thought they're leaving because that's the highlight of that child's dream, right? To be able to provide that. Now, $10,000 doesn't seem like a lot, but it compounds over time. So they're not planning on dying anytime soon. But if they do, there's at least a few years there to go. Well, who knows now what the price of what that costs to go to,
Right,
right?
right.
A $10 soda and a $55 hamburger and a
Yeah, yeah.
$20 balloon. So, but I mean, those are the two of the provisions that we've seen and how deep it goes. So, to recap, the living trust is an instruction. It's a contract that leaves instructions to your beneficiary of everything that you want, and it's a comprehensive living trust. It's not a 199 document. It's there. And when you work with us or you work with thestate.com, once you decide to work with us, what happens is we do a Zoom with you and we help you, we walk you through the process of filling in the questions because there's some like, what happens here?
For sure.
I have this and this, where do I put that? And it all goes down through a step by step, fill in the form, and then it creates a living trust and all of the documents that come with a comprehensive living trust. So,
I want to go back to the very
yeah.
beginning where you said there's not a lot of education around this stuff. It's not a people don't want to do it, it's that people don't know about it. And for me, now anyone who's listened to the show before knows I'm pretty against the public education system, especially when it comes to the adulting side of life when it comes to education, right? We don't see tax preparation in high school or, as a mandatory course in college. We don't see a lot of adulting based stuff. And I think this is included in that, where I think maybe when everyone turns 18 or 20 or whatever it is, it should be mandatory that they attend a course provided by either, the government or the state on will and estate preparation. I think it should be mandatory, but that's just my personal opinion. But that would be a way to educate people on it, and they'd have to be educated on it because right now it's like, unless you think someone is going to pass away in your family or you have medical issues or whatever it may be, especially on the younger side of the generations, they're not thinking about that and they don't know, what is entailed with it. So I do think there should be some kind of educational course out there that is put into the public education system or even like a college class or some kind of government program. So that's all I want to say in reference to you talked about people not knowing about it. Now, as far as it seems like the living trust compared to the will is you can just be a lot more specific and detailed. So I like that and I appreciate that because I think it allows you to have more control over what happens when you pass away. So would you say you could have like a locked up sum of money that your beneficiary can only access a certain amount every year on their birthday exactly? Could you do something like that?
Absolutely. You could the limitations of a revocable living trust or a comprehensive revocable living trust, because not all trusts are created equal, right?
Right, right,
The I mean the difference between a comprehensive living trust and the will is the limitations of the instructions you could leave are what's in your head, what's in your mind. It's limited to your imagination. That's it. You could do whatever you want because once you pass, it could never be changed. You're
right.
done. While you're alive, you can make as many changes as you want. And what we found over the years is that people start with the very bare basics and then they keep it because now that you have the living trust in the arsenal, excuse me, excuse me. Now that you have the living trust in the arsenal, you keep adding provisions, and a living trust cannot be changed. It's called a restatement. They add a provision on top of it. For example, we created this living trust. The living trust was dated on May 1st, 2020, and today is January of 2025. And they say the provisions in the May 20th, 2020 living trust that are now surpassed by the living trust that is dated January 1st. So you have to create a living trust. And this is another reason why we created the software, because if you go to an attorney, the cost is anywhere between the national average is about $3,500 to all the way up to $10,000. That's what we've seen attorneys charge. Um, and then they charge a maintenance because it's a living document. And in the name, it says that living trust. And being a living document, that means you get provisions. I'll give you an example. We have a client that has a living trust, and he's a YouTuber, and he has what's called faceless channels. And he keeps adding channels, so he keeps funding the living trust. That is not a change in to the living trust. He just funds it, which leads me to what makes a living trust a living trust. Not only does there's the additional documents that I'll get into, but there's three things. One, it needs to be signed in front of a notary. Two, it needs to be signed in front of two witnesses. So that way it's never challenged, and the court never has a doubt that you signed that living trust. So it can never be, it has, well, let me rephrase. It has never been challenged as of yet, right? There's not a case out there that I have seen that people have challenged it when it has those provisions. I mean, they could say, "Hey, my sister created fraud," but if she didn't, then it's there. And the third thing, and the final thing that attorneys don't do for you, that we do, and we walk you through, is the funding process, and that's putting the assets that you have into the living trust, because the living trust, one, protects it because it becomes its own entity and it owns the asset. You control it, but the living trust, it's owned by the asset is owned by the living trust. So you control it, you don't own it. That means you have to fund it. So those three things are required for the living trust to be active. Once the living trust once the living trust is um in the process and it's living, then you can take funds, put funds or assets in and take them out at any given time. The changes that are get updates is, for example, you have a young daughter and now she's a young lady and she gets married to a tattooed son-in-law, or that is good for three things: nothing, nothing, and nothing. But she loves him anyways, right?
Right.
And so now the provisions, I mean, we usually do this. Now we're starting to do this, so it prevents it from updating. But it says if something were to happen to Johnny, the son, or the beneficiaries, or her kids, gets the assets instead of the spouse. Because if you're married in California and you're a beneficiary to a trust, and you don't put that provision in that trust that the assets go to your child, the spouse gets them, because it's a community state
Mm.
law. So it becomes common law. It's a community state. So one of those provisions is, you say, I want my beneficiary to be my daughter, and if she is not available or no longer with us, those assets get held in trust until her kids become of age. Now,
Mm.
people always ask, what age? I mean, I want to give it to them at 18. I said, well, you could do whatever you want. However, I'll give you an interesting statistic. 25 years ago or 28 years ago when I started the first time home buyer to own a home, which means you start to build roots, right? You start to get married and build roots.
Right.
Was the average was 22 years of age. Today, the average is 35 years of age. That means that this generation is not thinking of building a solid foundation or thinking of building a family or building a foundation, even financially or partnering up, right? So I say take that statistic, do what you want with it, but sometimes giving somebody your lifetime savings of your retirement account or a 401k or an asset or to own an apartment building at that age is not necessarily. I mean, I could say, you know what? When I was 18, I wanted to do two things. I wanted to go out, and I wanted a fast car, right?
Yeah,
No
yeah,
expensive car or a truck, and I wanted motorcycle. I mean, with all the toys that I can afford, I was getting them, and I'd figure out how to eat tomorrow. I wanted it today
right.
because we couldn't live fast enough. So I always take that into. I always talk to people, and I think it's the stories and the experience. It's not. I don't think it's so much knowing the law, it's understanding how other people have used living trust to protect their family. That makes it even more of a strong document.
For sure. I've actually seen in my personal life, you know, younger folks who are graduating high school and they have a parent pass away, unfortunately, and they get, tens of thousands of dollars, and then they decide, well, I don't need to go to college right away. I can kind of like, milk this out for a little bit and figure out my life. And then they end up never doing anything. They end up never going to college. It's a shame because I know for me personally, as a younger man, if I got that money, I'd want to invest it, whether that was stock exchange or CDs or whatever it may be, right? But I've seen plenty of people from 18 to 20 or around that age who get a couple, tens of thousands of dollars from a parent passing away, and they decide to take a couple gap years, and it's
Yeah.
unfortunate. And for sure, I think you should definitely keep it until they're a little bit older and looking more to settle down, like you said. But I would say like post college age is probably a good point. 35, I mean, it just sounds a little bit too late, but it's definitely appreciated still. Now, as far as the living trust, you talk about making the restatements. So if someone works with y'all to make a living trust and then they want to make restatements, new provisions, do they have to pay each time they do that? And if so, should we make all the restatements at once? How does that process work?
Yeah, so give you an example. A restatement every year. For example, the laws never expire on your living trust. They don't
Okay.
expire. They're written there. However, if you need to do a restatement, there's different provisions that go in there. For example, the state of California has a minimum requirement that you have to have to not to go to probate. That's one of the biggest provisions that gets updated. The laws never expire. The contract is good. If you never made a change, the document will always prevent you from going to probate and the distributions happen. With us, well, unlike attorneys, the restatement provisions, you get unlimited provisions. There is a small fee. There is a small fee um for an annual fee that we charge $129, and we use that to be able to update the software, update the provisions through all 52 states. And that's where that money goes, and so we can keep the software live. The year that you need it, you pay it. If you don't need it, then your account, you just locked out of the account until you pay the 129, and then that year you make as many changes as you want for $129. And that helps cover the cost to be able to keep the software updated and the legal provisions and to be able to make that. So, and the most important thing is that we always tell people the beginning when you start your living trust, that's when the relationship begins. And what I mean by that is that we're always checking, we're not always checking in, but we always send out a lot of, we check in digitally, right? Because there's only so much we can do. We always say, hey, it's time to review your living trust. You should look at it. And I always tell people it should be a minimum. You should always look and think about your assets and think about the living trust at least once every 2 to 3 years. Review it. What does that mean? Did you, and what are the changes? Now, you don't have to make a restatement every time you get an asset. You just create a funding letter. Now, when you work with an attorney, most attorneys, not all of them, because I ran into two a few weeks ago, they help you fund them. Most attorneys give you a 9-page document and they give you the sample letters and they say, here's how to fund it. Good luck. And that's all, we do that. When you need a restatement, come back and we'll charge you some more money. And then so what we fund it, and then so there's 3 things that you should look at. One is, have I accumulated more assets that are not assigned or that have not been funded into the living trust? Another home, another retirement account? Did you come into a windfall of money? Did I create a contract, right? Because you can put your contract, a contract for if you're a content creator or you're a digital creator or you have a course, you put the beneficiary or the owner to be the living trust. So that income comes into the living trust for the rest of your life, whether you're alive or not. So your beneficiaries can always continue to, like oil well contracts that we just did, a family in Colorado this is the 3rd generation and that they had, so that living trust can continue to exist and be able to do distributions, right? Some of those oil contracts are huge, by the way.
Right.
I mean, that's like, man, do you have enough time to spend that money? That could be a full-time job. The another provision is, did you add, is your family growing? Is there another grandson, daughter, stepson, or is there another beneficiary that came into your life? You don't want to disinherit them by accident, right? Disinherit them by accident. If they're not named and they're not acknowledged in the living trust, it's a contract. They don't get anything. So updating it is I call that like the disinheritance by accident, by just not keeping up with it. And the third thing would be is, if there is any changes that you want to do. For example, one of the things that we said, if they can have access, when I was talking about you shouldn't get all the assets until you're 35, I didn't mean like cut them off dry. You put provisions in there and say, hey, listen, if he wants to go to a trade school, he should have access to that. If he wants to start a podcast, or if he wants something, or start a business, or start something that can give him a little bit of seed money, put X amount, he can do this in order to make a living. If he wants to start a business, if he wants to go to school, if he wants something to improve that is in that provision, you can put that provision so he has access to it, but he can't go out and buy a Ferrari, right?
So that's the beauty of the specificity of a living trust compared. Now, a will, how limited are the provisions in a will? So can you do some of this in a will, or you can't do any of this specificity at all?
It has 2 pages. A will, and here's the reason why you can't with the will, because it's a love you will. I love you, I give you everything. That's it. And then the court still has to come in and decide. So, you have 2 plans. One is you have the government's plan, where they decide, they make the final decision on what happens to your kids and what happens to your assets. What do I mean by kids? If you have young children and you pass, what happens to them is they go into social services. I call that child jail, right? Because social services takes them into the system if there's no provision, until somebody comes forward and says, I'll take them. And then the state will give it to them. temporarily, and then they have to go to hearings. To prevent that, one of the documents in the estate plan, it's called it's a guardianship plan. So
Hmm.
one, you have there's three portions, there's three parts to a guardianship plan. One is a temporary plan. And we always recommend that you have somebody within 1 hour away from your home that loves your kids or that you trust with your kids, right? They don't have to love your kids for temporary, right? Because it's temporary. Um, they just have to be good human beings, right? In your eyes. And that's a temporary custody. And temporary custody means that it's anywhere from 3 to 6 months, maybe 12 months, could be temporary, right? And there's no specific time until the until the people that are in the section of permanent guardianship come into play. And I'll give you an example when that can come in, and we've seen it, is mom and dad go out to dinner, they leave the kids with the babysitter. They go out to dinner and they get in a tragic accident and they become incapacitated. They become unconscious, they're in the hospital. Those kids with the babysitter needs to know who to call, who they need to know what happened, so that provision with the guardianship contract or agreement, a guardianship plan, is usually on the side of the refrigerator and says, hey, if something were to happen, Johnny, give this to Auntie Joe, right?
Right.
This if something were to happen to mom and dad, this document on the side of the fridge is where. Babysitter, something were to happen, this document has anything and everything you need if you need it to be an emergency. That's where a temporary guardianship could come into play, while the permanent guardianship. And the permanent guardianship is what happens if you pass. Where are the children gonna go? Right? Not only your
Right.
money, but the children. The second and the third and final, I call it uncle, the drunk uncle provision, which is who do you not want your kids with, right?
Mm, yeah, yeah.
That cousin, because there is in some families, they're just there's
Yeah. Yeah.
that one family member, right, that is just not there. um so that is part of the provisions in the estate planning and the guardianship. So knowing what happens to your kids is not only going to give you a peace of mind. So that goes to, let me go into the second document that is really important, which is called the power of attorney. I'm going to
Right.
go in a power of attorney for financial. Now, it's up to you. You can have the same person be different people, but the financial power of attorney, how we've seen it used, is um, dad got hurt at work and was in the hospital for about 8 months. Mom left her job to be with her husband every day. And the only reason why she was able to do that is because the 401k, she had the financial provision of the power of attorney. She was able to withdraw money because there's only three ways on how you can borrow money from your 401k, turn 59 and a half, or you become disabled. And she used the provision of being disabled into the 401k to be able to withdraw monthly the monthly income needed to sustain the house while dad was in the hospital every day. Mom decided that she wanted to be there with her loved one, right? With her partner, her lover, her boyfriend, whatever you want to call it, but she was there and she had the power of attorney. She was able to withdraw and be able to spend time with them and to help him recuperate as quickly as possible. And because of the power of attorney now, because many people say, well, you know what, I don't need a living trust. I will, I already have a beneficiary. Well, the beneficiary only gets access to the funds once you're dead. They can't use it on your behalf to be able to sustain the family. So
Right.
that's a super it's a tragic one, but that's how a power of attorney works and when it can be done to make sure all your bills are paid. because a beneficiary only gets access to that. Now, the power of attorneys only are alive while you're incapacitated. When you're dead, when you die or you pass, the provision in the power of attorney, excuse me, dies with you. So they have no more power. Now the living trust takes over because now you're passed. The third document that comes, that which there's about total of 12. I'm just going to go over the top 5 because these top 5 have major benefits that come with the living trust, because the living trust is like the umbrella, and all these documents are the things around it that are underneath that living trust. The second thing is called a pour over will. A pour over will, now it's not, a pour over will is designed in case you buy an asset and it did not get put into the living trust. It's in between that 2-year period or whatever you
Right.
put on your calendar. You go to Florida, you buy a condo, you come home, and you get into and an accident happens, and you're no longer here. Hey, dad, mom, dad had a condo in Florida. It didn't go. The pour over will there's some special provisions in the pour over will that states, if, because you still have to go to probate because it's not in there. But what makes it simplified is that a pour over will would tell the courts that you want it into your living trust. And the provisions in the pour over will says if any of the beneficiaries object to this asset going into the living trust, they are disinherited. And the reason that provision is in there is to make the probate process go quickly, and so they can transfer the asset as economically as you can.
Mm.
Because, which leads me to once again go back to probate. The average cost in probate, every time, the more assets you have, the more it costs. Why? It's just, I don't know. I guess they want a percentage, right? But the minimum of cost to go to probate, if you own a house in California, is $26,000 today. Today it's 26,000, and it keeps going up. The minimum amount that most people, because I mean, a mobile home is almost worth 500,000 in California now. So um, that's where that provision lies, and how a pour over will works. Now the last document that I want to really share some light on is called a healthcare directive, and that gives them the power to be able. It has 2 sections. One is what happens to you if you become incapacitated, and what you want done. The But it also has a what's called a HIPAA waiver, because now in the state, the doctor will tell you or your spouse or about your mother, they'll tell you everything you want to know, but they won't give you any records because your mother did not sign a HIPAA waiver, that she did not give you permission to get her records to get a second opinion. Now,
Mm.
is that important? In every case, it depends, but you want to have that option. If you
Right,
want
for
them,
sure.
you want to be able to pull them. So the healthcare directive has that waiver to be able to do that. Now, if we all knew that we were going to get sick, we'd probably right before we become unconscious, give me the HIPAA waiver, I'll sign it to give it
Right.
to my son, right? But we don't know when. And so it's the healthcare directive, the power of attorney, the guardianship, and um the power of attorney. Those are probably the 4 documents that you should have, very bare minimum. There's more on there, but I don't want to, that you should go in there, but there's many mechanisms. Every case is a specific to each one.
For sure, and we're gonna have your website and the information in the description below, so anyone who's curious about those other documents can get connected with you to find out more. But essentially, what you went over is you're establishing a living trust so that when you pass away, your assets are divided properly. Your beneficiaries, if they're children, are put into the proper guardianship. And then, if anything happens to you medically, you have someone who is in charge of you and can take proper care of you. And I definitely emphasize picking that person wisely, having someone who understands your medical beliefs. So if you're a person who is against certain types of operations or has certain beliefs about whatever it may be, whether you're incapacitated or in some kind of medical state, that they know that about you. For example, I know people who they want someone in charge of their medical stuff who will pull the plug on them immediately. There are some people who want someone who will keep them a certain amount of days, and if you have kids and if you're married, obviously it gets a little messier. I know there are certain people who are against certain types of medications, and if you're that kind of person, you got to make sure that whoever is put in charge of your medical health when you're incapacitated is aligned with that. So definitely
Yeah.
be thinking about that. I think, like you said, it's important, definitely, as any parent, to want your children, in the worst case scenario that you're not there, to be raised by the right people, especially not just thrown into the wind, so to speak, of the government. So for sure. So that's all under a living trust. And then definitely recommend it if you're like a collector and you have a lot of assets that you want certain people to get parts of. I know, like for me, I've established it where my youngest sister gets this certain type of stuff that I collect, and then my other friends get this certain type of stuff. So I
Sure.
love the specificity of this. And for everyone listening, I know, Mr. Vasquez, you have a special discount code for my listeners who want to work with your
Yeah.
services to establish
I
this.
have a couple gifts. The first gift is that you can go to the estateDocPrep.com, and you can get a free comprehensive guide. Now, just because it has all the questions doesn't mean that guide is a living trust if you're able to fill it out. Okay. It's just a guide on all the
Right.
questions that you have. So you can go to um, State Doc Prep guide, and /guide, and you can download a free guide to give you all the questions that you should, and then be able to give you a summary of what we talked about. Two, you go, and if you decide that a estate doc prep and a living trust is for you, is you could use coupon code couple O, and I'm sure we'll put that out down in the version.
For
Couple
sure.
O will be the coupon code, and you will save for the first 10 listeners. You will save $1,000 off of the comprehensive estate plan, and that includes unlimited updates, restatements for the next 12 months. And if you have questions and you have a special case and you want to have fun and or talk to an artificial intelligence receptionist, that is, I call it sometimes, because I say, hey, how do I do this? So we created a artificial intelligence receptionist customer service artificial intelligence at 805-909-4689. She'll answer any questions within the 52 states that we have provisions in, within the 50 states that we have provisions in. She won't try to sell you. She's not going to do anything. She's there to give information and educate you on any provision. This is an artificial intelligence receptionist. That is my assistant. Now, at the end, she will ask you, would you like to set up an appointment to talk to a human? Or would you like to talk to a human now? She'll transfer you to me or one of our estate planning coordinators to be able to do that. Those are the three gifts. And I say a gift because I had somebody literally ask it on the phone to create a rap about some topic, and it literally rapped on the phone and said, "Oh, here, yeah, I can create that," and it created it, rapped, and it rapped up a song. It described the bird. I'm not saying to call and play with it, but I'm saying if you have an estate plan question, I've been very intrigued with it because I call it every so. I mean, I have a speed dial on my phone now because whenever I have a question, I'll just call it and ask it, and if not, to make sure that the provisions are there. Take it into consideration. It is AI. It's not 100%. We're not giving legal advice. It won't give you legal advice, but it'll tell you how you could use a living trust, and it'll tell you if you can benefit. Before I go, I'd like to just say end with a couple of things. One is, who needs a living trust? Everybody needs a living trust because we all have an estate. We all have an estate, whether it's a small estate, a large estate, everybody needs it. So one of the biggest misconceptions is that it's only a living trust is only for the wealthy or to save taxes. This living trust is not to save taxes. This living trust is to protect your family and your assets from the government deciding on what happens. Two, if you own a home, every state in the land goes to probate. So if you own a home, you need a living trust. That 68% of homeowners don't have it. Two, if you have young children and own a home, you must have it, or your children are going to go to child jail or social services if something were to happen to you. And that's a trauma that I think you can never recuperate from. And three, tomorrow's not promised. Yesterday is gone and it'll never come back. So the best time is today to be able to practice or be able to protect your family. So I would recommend that anybody, it's never too late, as long as you're there. So that's where we're at with that.
Right. Ladies and gentlemen, whether everything you have is just a humble small collection or you have a lot of property, whatever it may be, you have worked to some degree to obtain those assets, whether it's furniture, whether it's money, whatever it may be. It has memories connected to it. You have worked to have it. Why would you just throw it away? So make sure you protect it. Make sure you protect your family and your children, as well as yourself and what you've worked for. So, Mr. Oscar Vasquez, so great to have you here. I appreciate your time. And again, we'll have all your information in the description below so people can look further into all the details with this as well as work with you. But thank you for coming on the show and helping educate people on something that is just not properly educated out there. And hopefully everyone has learned a little bit more about what happens after they pass and what they can do to make it easy for their loved ones.
Mr. Whiskey, thank you for having me. It's been a great pleasure.
Sailing through the ocean blue, nuclear reactors my crew, guiding the ship, the stars as our guide, through the waves we ride, jokes and laughter fill the air. On this voyage we have to share, working together, side by side, as one family we will abide. In the heart of the ship we reside, nuclear operators with pride, powering the vessel with every stride. Our mission, a source of great pride.